May it please the court, counsel. My name is Jeffrey Jensen. Along with Ms. Jordan, we represent the appellant, T.H.E. Insurance, who appeals from a final order granting summary judgment in favor of the city of St. Petersburg. The sole issue of this appeal is whether the phrase certificate holder is listed as additional insured with respects to the general liability operations of the named insured only is ambiguous on its face and thus ineffectual to exclude coverage for claims predicated on the city's own negligence. Coverage for a claim is based upon the face of the complaint, and in this case it is undisputed that the city is being sued for its own negligence. The city so stated in paragraph 7 of its summary judgment motion that it was being sued for its own negligence. What is being challenged in this case is whether an additional insured can assert a strained interpretation of a policy provision to nullify the exclusion for the purposes of gaining coverage for a claim. This case arises from an accident that occurred on a water slide during an extreme mud wars event that was co-sponsored between Active Endeavors Incorporated and the city of St. Petersburg. In this case, the city of St. Petersburg, who was a participant in the event, owned its own water slide, brought the water slide to its own property where this event was being held, which was a city park. It set up the water slide and it supervised the use of the water slide with its own personnel. Active Endeavors had no part in any of those events. The only thing Active Endeavors had was a volunteer at the end of the water slide that directed participants to the next event, but it had nothing to do with either the setup, maintenance, or property regarding the water slide. That was all the city of St. Petersburg. Page 1 of the policy governing this case has general liability coverage. And in that coverage it says it would pay for property damage or bodily injury claims that the insured became legally obligated to pay. The policy excluded numerous other types of liabilities such as contractual liability, liquor law liability, pollution liability, and advertising liability. I believe that the coverage exclusion that said that the city was an additional insured only for the general liability operations of the named insured only made it clear that there would be coverage only based upon claims of either vicarious liability, where the city was held liable for an action of Active Endeavors Incorporated, or direct liability, where the underlying cause of the liability was an act of the named insured, which would be Active Endeavors Incorporated. The case Garcia versus Federal Insurance Company is instructive here. In that case, the Florida Supreme Court held the policy language, a covered person means any other person or organization with respect to liability because of acts or omissions of you or a family member, was not vague and was effective to deny coverage to an additional insured for the additional insured's own negligence. On page 292 of that opinion, the Supreme Court stated, when considered in context, these words clearly indicate that an additional insured is only entitled to coverage concerning liability that is caused by or occurs by reason of acts or omissions of the named insured. An additional insured's liability thus must be caused by the acts or omissions, that is, the negligence of the named insured. In that same opinion, page 291, the court held that interpretations of a policy provision must be reasonable, and that is consistent with general contract law, where the contract's not going to be construed in a matter that would have an absurd result. In the instant case, the policy language is even clearer that the negligence has to be on behalf of the name insured. The policy exclusion... Is there any other alternative interpretation of that language? I don't believe that there is. I know the city is arguing that it could pluck the only after named insured and put that in front of the general liability operations to argue that the policy exclusion is only for general liability operations of the named insured.
So it wouldn't apply to other liabilities like advertising, I think, was one you mentioned, and there were several others.
Under the policy, all those other types of liability were excluded. There was no coverage for those anyway. So the only thing that there was coverage for, I believe, under the policy was general liability coverage. And that was what the additional insured was named as an additional insured for, provided that it was for the operations of the named insured. In this case, the use of the word only pursuant to Garcia was not necessary because it specified it was for the operations of the named insured, but they made it even more clear by saying the operations of the named insured only. The city relies on the cases Florida Power and Light Company versus Penn America and Container Corporation of America versus Maryland Casualty Company. These cases are distinguishable. The Florida Power case used the terms, but only with respect to the operations by or on behalf of the named insured. And in that case, I believe there was an issue of what's on behalf of. You could have somebody who's doing direct negligence. The negligence was a direct act of the additional insured, but the additional insured was doing an act on behalf of the named insured. That was something that was vague. The Container Corporation case notes that if there was an intent to limit coverage to accidents caused by the named insured, the certificate of insurance could have expressly so provided. And in finding no such language, coverage was found to exist by the Container Corporation Court. As cases are decided by this court, the sister circuit courts, and the Florida Supreme Court, insurance companies modify their language to comply with the new decisions. In this case, the phrase "on behalf of" was omitted from the exclusion clause. Other cases that were cited in Florida Power and Light and Container Corporation had vague language such as "arising from the operations." That phrase was also omitted, and on top of that, they inserted the word "only" after named insured to make it clear, pursuant to what the Container Corporation had said, that it was for only the operations of the named insured. Now there is a dispute on what does operations mean. In the absence of a definition which is not provided in the policy, operations takes the ordinary definitions found in the dictionary. And in the Container Corporation case, the court held that operations means a doing or performing, especially of action. In this case, all the performance that caused the alleged act of negligence was from the city. That was nothing that Active Endeavors Incorporated did to cause this accident. Therefore, there should not be any liability on behalf of, there should be no coverage for this claim. If the court has no more questions, I'm done with my presentation.
Sure.
Morning, may it please the court. Sharon McNovich on behalf of the appellee, the insured City of St. Petersburg. This is a case about an insurance company trying to get out of its obligations to one of its insureds where the policy language, as interpreted by courts in Florida and around the country, provides coverage. So before I get started, I'll just go through a brief outline of what I intend to discuss depending on questions. First of all, public policy favors coverage in this case, and I'm also going to talk about some of the applicable rules of interpretation. Second, I'm going to briefly go over the facts of this case, and then talk about how similar policy language to what we're looking at here has been used by other courts and how it's been interpreted. And then I'll talk about how the city's interpretation that there's coverage aligns with both public policy and common sense. And then if we get to it, we'll talk about the arguments made in the briefs about whether there were any factual disputes remaining. The city doesn't believe there were any, but T.H.E. argued in its brief that there are. So first of all, public policy favors coverage, and when we're looking at an exclusion, which is what T.H.E. is claiming this language is, those are to be strictly construed against the insurer and in favor of coverage for the insured. And anytime that there's ambiguity, that's to be interpreted in the broadest manner possible to affect the greatest extent of coverage. And that's for a couple of reasons. One reason is because the insured is relying on coverage, and also because the insurance company is the one that writes the policies. So if they put ambiguity in the policy, it should be on them to cover the insured who expects to be insured. And lastly, that the intent of the parties is an important consideration in determining what language means. And the intent of the parties can be considered based on the language in the contract, the subject matter of the contract, and the purpose of the contract. So briefly, just the facts of this case: we had Active Endeavors that was an insured under T.H.E.'s policy. They wanted to put on this event, the Extreme Mud Wars event, in the city of St. Petersburg. And there's a process whenever anybody wants to put on an event in the city where they have to fill out an application and go through an approval process. So that's what happened here, and one of the requirements is that the city required, in order for them to put on the event, is that the city had to be named as an additional insured on its policy. And so that's what happened. That's how we got this language that we're looking at today. So the certificate of insurance says that certificate holder, which is the city of St. Petersburg, is listed as an additional insured with respects to the general liability operations of the named insured only. Now, this exact language has never been used that I could find in any cases in Florida law. There's probably a lot of reasons that nobody's used it before, but there's similar language that's been employed. For example, Florida Power and Light is a case that T.H.E. discussed, and the language in that policy provided that Florida Power and Light was an additional insured, but only with respect to operations by or on behalf of the named insured. And in that case, the court held that Florida Power was an additional insured for its own negligence, and the reason for that is because there was no language in that provision requiring fault on behalf of the named insured. So all it required is that there would be coverage if whatever the negligence was arose out of the operations by or on behalf of the named insured. That's the same thing we have in our policy here. There's no requirement that there be fault or negligence on behalf of the named insured, only that the city's additional insured with respects to the general liability operations of the named insured. So the only requirement is that it arises out of the operations of the named insured. So after Florida Power and Light, that was in 1995, another case came out, Container Corps of America versus Maryland Casualty Corporation. That's a Florida Supreme Court 1998 case at 707 Southern 2nd 733. And that had similar language to what we saw in Florida Power and Light, also similar to what we have here, where Container was named as an additional insured for operations at operations site by Southern contractors. So again, we see that there's a requirement that the negligence arise, that the case arise out of the operations of the named insured. But again, for the same reasons, the court held that the additional insured was covered for its own negligence because there was no limiting language requiring fault by the named insured. So it's the same scenario where it does require that the accident arise out of the operations of the named insured, but that there's no requirement that the named insured be the one that's at fault.
And this event was co-sponsored? Is that an actual term or a loose term?
That's a term that the city uses. Basically, we have some testimony in here about what that means, and that's in the record at 157, the deposition of Sean Druin, which is a city employee, where he explained that the co-sponsor turns in an application and they go through an approval process, and then the city will offer some services like EMS and fire and rescue. So we just kind of help them with the event to make sure that it's safe. But it's their event that they decide that they want to put on, and the city permits them to do that with certain conditions. And so in this case, one of the issues is, what does operations mean? And I agree that since it's not defined in the policy, that we can use just normal definitions that we can find in a dictionary. That was one of the issues in that Container Corps case, is what did operations mean? They were trying to figure out how to interpret that under the policy. And in that case, the court explained that because operations was not defined in the policy, it should be construed in favor of the insured. And in this case, consistent with the policy language and the intent of the parties, operations should be interpreted to mean any event that's sponsored by active endeavors. So in this case, we have an event sponsored by active endeavors. That's the Extreme Mud Wars event. The accident arose out of that event. The slip and slide was part of the Extreme Mud Wars event, and the plaintiff in the underlying case claimed that he had an eye injury when he went down the slide. So this accident certainly arose out of the operations of the named insured. And to further buffer that, in the record we can look at there's an endorsement on the policy that clarifies what the policy applies to. And this is at page 115 of the record. And so it explains, it is understood and agreed that this policy applies to any injury to any person while participating in any event which you sponsor. And there are some other words in between there, but the policy applies to any person that's participating in an event that Active Endeavor sponsors, and that's what we have here, an event that's sponsored by Active Endeavors. So the difference between these two cases that I talked about, Florida Power Light and Container Corps, which those cases also cited a number of cases from Illinois, the 10th Circuit, Pennsylvania, all having similar language and all be interpreted the same way, where if there's no requirement of fault on the behalf of the named insured, then the additional insured is covered for its own negligence. So it doesn't matter whose fault it is. If it's the city's fault, it's the named insured's fault, the city's covered because there's no requirement in that policy language that the fault be the named insured's fault. In Garcia, which is the case that T.H.E. is relying on, we have a very different language, and that's why the result was different. In Garcia, the coverage was extended to any person or organization with respect to liability because of acts or omissions of the named insured. So there we have that acts or omissions language, which is the court said that the reason this language is different from those other cases is because the additional insured's liability must be caused by the negligence of the named insured. That's what the policy says. And Garcia also cited a number of cases from, also a case from Pennsylvania, which was cited in Florida Power, where that case was distinguished in Florida Power. It was Consolidation Coal versus Liberty Mutual Insurance Company, 406 F sub 1292, Western District, Pennsylvania, 1976 case. In that case, they had language where the additional insured was an additional insured, but only with respect to acts or omissions of the named insured. And then again, that's the reason why that interpretation denied coverage for the additional insured, because it had to be the acts or omissions of the named insured that led to coverage. And same thing with Garcia, but that's language that we don't have in our case. All we have in our case is that it has to be from the operations of the named insured, which there's really no question that that Active Endeavors was putting on an event, and that's what their operations were. And there are a number of other cases cited in Garcia, also from Illinois, Ohio, and Texas, where they're looking at the same kind of language where the additional insured is not covered for its own negligence, where the policy language talks about acts or omissions. So that's what all the cases say. They're all consistent across the nation and throughout Florida, that if the policy only specifies that the additional insured is insured with respect to the operations of the named insured, then the city would be covered for its own negligence, and that's consistent across the nation. Now, another issue with T.H.E.'s interpretation is that it renders the entire additional insured provision meaningless. So the city asked to be listed as an additional insured, and the hope was that the city would then be insured for something. But the problem with T.H.E.'s interpretation is that the city would only be covered if there was a vicarious liability situation. But there are no scenarios under which the city would be vicariously liable for the acts of Active Endeavors. So, and that was admitted at the hearing, that there's really no vicarious liability that would attach in this situation, meaning that the whole the whole coverage means nothing at all. The city would never be covered because the city would never be vicariously liable for the acts of active endeavors. So one of the arguments that T.H.E. was making in the brief was that, well, the word only would be rendered meaningless if we looked at the city's interpretation. Now, first of all, it would be more of a problem for the entire coverage to be rendered meaningless than just that word. Second of all, only could be applied to any number of words in there, and only is used in a lot of the other cases to, it could apply to operations. When it's placed at the end of a sentence, it's not clear grammatically what only is supposed to be applying to. It's also one of those words that you can use that it doesn't necessarily have to mean anything. Like, you can go to the drive-thru and say, I want to order a hamburger only. They're only going to give you a hamburger whether you say only or not. But the other issue with only is that the word only was not used in that Garcia case that T.H.E. is relying on. And Garcia had actually argued to the court that the absence of the word only rendered that policy ambiguous. But that argument was rejected. The fact that only wasn't in there didn't make any difference. Just like in this case, the fact that T.H.E. put the word only in there doesn't entitle them to whatever interpretation they want in order to have the city excluded from coverage. So the other issue, and it wasn't discussed, so I don't know how big of a deal T.H.E. wants to make of it, but there were some arguments in T.H.E.'s brief that there were still issues of material fact that were remaining that the lower court didn't have a chance to decide. I think that T.H.E. waived any arguments to whether there were issues of material fact remaining, because it actually did a cross motion for summary judgment where it claimed that there were no issues of material fact. It was asked at the hearing by the judge, what are the factual disputes, and the only factual disputes that T.H.E. pointed out are the fact that the city owned, set up, and operated the slide. Those are not material to the issue of coverage, and they're not even disputed, so there are no factual disputes that T.H.E. ever pointed out that would have actually made a difference in the case. But even if there were, this is not the time to say, oh, there were more facts that I wish I would have known about, because they could have discovered those facts. They could have told the judge, the trial court, let's wait, we have more facts that we need to discover. But the fact is that there were no more facts. We had all the facts that we needed. The interpretation of this policy is a pure question of law, and it was appropriate for the trial court to make that determination. So, in conclusion, all doubts are to be resolved in favor of the insured. Public policy favors coverage in this case. Coverage is consistent with the party's intentions, and an interpretation that the city's interpretation of the policy language is that there is coverage, and that's a reasonable interpretation that's more reasonable than the interpretation that was set forth by T.H.E. It also aligns with public policy. So at this time, the appellee would respectfully request that this court affirm the decision of the lower court that provides coverage to the city for its own negligence.
Thank you, Ms.
Thank you.
Winovich. Mr. Jensen?
Just addressing public policy, there's more than one public policy in play in this case. Public policy also favors the enforcement of contracts, and we had a contract for insurance here that was plain that coverage was going to be afforded only for the general liability operations of the named insured only. And in this case, operations as defined by the container court was just the acts of the named insured. The subjective claim that the only could be modified somewhere else does not make a claim policy provision ambiguous. It's an objective inquiry, and I think the objective inquiry here shows that only modifies named insured. If it was to modify general liability operations, it would have been additional insured is only an additional insured for only the general liability operations, the named insured. That provision was not written that way, and I don't think it would make sense to even have that written that way, because the contract of insurance only provided coverage for general liability operations. There was an argument about the intent of the parties. The intent of the parties between Active Endeavors Incorporated and the City of St. Petersburg is irrelevant. The Container Corp case dealt with that. There was a contract between Container Corporation and Southern Contractors. There was a provision in there regarding who would be indemnified for what. The Container Corporation Court rejected any analysis of that agreement, finding it's the policy language in the insurance contract that's controlling, not what the agreement between the parties were. So it's irrelevant what Active Endeavors and the City of St. Petersburg wanted or not wanted, and the record is unclear what their intentions were. It's the insurance contract that's controlling. There is a definite benefit to the policy language. The city is not only indemnified for vicarious liability should Active Endeavors do something, but the city is also indemnified for direct negligence of the city if that act was attributable to Active Endeavors. For example, if Active Endeavors did something during its general liability operations to create a dangerous condition on the property, the City of St. Petersburg, as the property owner, is directly liable for the existence of that dangerous condition and the failure to abate or warn. If somebody were to sue the City of St. Petersburg for that dangerous condition that injured them, there would be coverage because that would be something arising out of or that would be something attributable to general liability operations. As the appellee admitted, there's no case with policy language this way. This was something that had evolved from the Container Corporation case, where the court said if there's an intent to exclude coverage, then it should say so in the certificate, and that's exactly what T.H.E. Insurance did. It made clear in the certificate of insurance that there's only coverage for the general liability operations of the named insured only. That's the reason why that's there. With regard to the comments about whether or not there is anything else out there that should have been considered by the court, the question of whether or not there is a duty to defend for the city was a two-part question. The first part was, is there coverage? The second part was this a covered event? And what the trial court did in its order was it decided as a matter of law that the policy provision is ambiguous and ineffective and therefore it's coverage. So it never reached the second question. So I believe that it was not appropriate for summary judgment in this case. And we would ask the court to reverse the summary judgment that was entered against the city and to grant the summary judgment in favor of T.H.E. Insurance. Thank you.
Thank you, Mr. Jensen. Court will be in recess for 15 minutes.